Mm-hmm.
So the objective evidence that they're typically looking for isn't there. So that's what makes it harder to win, period. Now, I personally believe that fibromyalgia is a diagnosis because it's outlined as a diagnosis, and I'm not a doctor, right?
Yeah.
Social Security and people in doctors, they talk about the 18-point tenderness test, right?
Mm-hmm.
Okay. It is subjective. And if you memorize all 18 points, I guess you could fake it, right? At least that's what a judge, a couple different judges has told me, well, they could have just memorized the 18-point tenderness test and faked it. Okay.
Yeah.
Sure. But let's assume they didn't, and they're pretty consistent. The other thing about fibromyalgia, and that I think makes it difficult to win, is that not just that it's an 18-point tenderness test, there's a lot of sometimes which is the right doctor to diagnose it, because under current healthcare systems, not everyone has great health insurance. So a lot of times you maybe just getting your PCP to diagnose it versus a rheumatologist. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
Yeah, and one other thing in that same vein is, let's say you just got out of prison and you've been incarcerated for a period of time. You do not collect benefits while you're incarcerated because the state or the government is already supporting you during your period of incarceration. So that's just something to bear in mind as well.
Right, that's correct. So a lot of times people are like, I got out of jail yesterday, let's apply. Okay, but you don't get the back benefits if you've been in jail for the months you were in jail or prison.
Mm-hmm.
You don't get back pay for those months going forward. The number 4 thing that we talked on the most difficult cases to win is fibromyalgia and having that diagnosis. Why don't you tell us a little bit why you believe those are kind of a bit more difficult to win?
Well, fibromyalgia is a very unusual diagnosis, and I'd say probably 10 years ago, it was much more frequently diagnosed than it is now. And in order for it to be a legitimate diagnosis, there has to be whatever your problem is. And let's just take a typical fibromyalgia case. A person's got memory problems. They've got what's called mental fog periods, where they just, they're just kind of confused. They've got fatigue, chronic fatigue. They're sleeping a lot. They're depressed. They've got body pain, usually pretty much all over. So you have to be able to exclude all other causes for that. And here's a typical example. Individual has back problems, both low and high. So they've got cervical and the neck problems, and they've got lumbar problems. Okay. And so they've got chronic pain from that. And let's say the neck problems are causing problems in their arms. That's pretty typical. So let's say a doctor diagnoses fibromyalgia. Well, I would think that it's probably more likely than not that their exertional problems are caused by physical organic cause. For instance, degenerative joint disease or degenerative disc disease in the back and the neck, and maybe something else. But the doctor has to exclude all other causes of impairment before diagnosing fibromyalgia for it to be, and that's under the regulations, for it to be a disabling impairment. The other thing is that fibromyalgia is kind of evolving. The science related to and the medicine related to fibromyalgia continues to evolve. And for instance, it's not unusual now to see people who are chronically depressed to develop physical problems that basically are caused by their depression. So, then you've got a case where you probably should get your client evaluated by a psychologist and see. And there's also somatoform disorder, which is a psychiatric disease, but it manifests itself as physical problems. So with fibromyalgia, it's a very difficult diagnosis to accept if the doctor's not ruled out all other causes.
Yeah, so here's my thought on it. And you and I can chat about it after. Let me give you my thoughts. I think what makes fibromyalgia tougher to win is that there's a crop of judges that have this perception that it's not a true diagnosis. It may not say that because the regulations say it is, but it's because there's no imaging studies that can be done. There's no X-ray or MRI that can prove the pain disorder of fibromyalgia or the symptoms of fibromyalgia. There's no blood test like so clearly with like diabetes or you name it.
Mm-hmm.
So the objective evidence that they're typically looking for isn't there. So that's what makes it harder to win, period. Now, I personally believe that fibromyalgia is a diagnosis because it's outlined as a diagnosis and I'm not a doctor, right?
Yeah.
Social Security and people in doctors, they talk about the 18-point tenderness test, right?
Mm-hmm.
Okay. It is subjective. And if you memorize all 18 points, I guess you could fake it, right? At least that's what a couple different judges has told me, well, they could have just memorized the 18-point tenderness test and faked it. Okay.
Yeah.
Sure. But let's assume they didn't, and they're pretty consistent. The other thing about fibromyalgia and that I think makes it difficult to win is that not just that it's an 18-point tenderness test, there's a lot of sometimes which is the right doctor to diagnose it, because under current healthcare systems, not everyone has great health insurance. So a lot of times you maybe just getting your PCP to diagnose it versus a rheumatologist, right? And so getting a rheumatologist in the room to diagnose it with the, 18-point tenderness test and kind of the different criteria through the Social Security guidelines isn't easy as well. So we had talked about having the right medical expert in the room. Then all of a sudden we're talking about discredit. Well, I don't believe this fibromyalgia diagnosis because it was done by a primary care physician, and I'm quoting judges, versus a rheumatologist. Well, I tried to get the one, but my insurance wouldn't accept it, blah, 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 right? All legitimate reasons, but to your point, the burden of proof is on the claimant. So what makes it difficult is that I think is a perception, and I've been at this for 25 years now, the perception from a very kind of a, what's the right word, a more seasoned judges, old judges, that's not a real diagnosis because you can't prove it to me by imaging. And there is a judge who's now retired. He brags about this to me, and I don't know why. We went to lunch. You know him, and I'm not going to name drop him, but he'd be like, I would always just ask the lawyer, point out to me one piece of evidence in the file that you can prove to me that the fibromyalgia has been legitimately diagnosed by objective evidence. Well, sure. Now let me show you Santa Claus in the North Pole because it doesn't exist, right? So you're asking, you know, the answer to that. I can't say I can't do it, but that's not the rule.
Well, no. And so when I was a judge, and I still make this point, it really comes down to the credibility of the claimant, because it doesn't matter. The bottom line is whether the person has or does not have fibromyalgia doesn't make a whit of difference if they're credible and their pain is caused by a somatoform disorder or depressive disorder or, degenerative disc disease or carpal tunnel syndrome. It doesn't make any difference if they're credible and they've got the medical evidence to back them up of persistent complaints over a period of time that would, cause a person to have the same symptoms as fibromyalgia. It doesn't really matter what the diagnosis is if they're credible and they have the problems that one would have with fibromyalgia.
Yeah, no, I love that. I mean, it comes down to credibility. Are you consistently telling the same story to your medical doctors than you are to the judge? And I use the story because it's a true story. Are you telling your story, which is true, both consistently to your doctor and on the day of testimony? But what frustrates me to all none is these judges that get so entrenched into being right.
Yeah, that's...
why are you talking fibromyalgia? That's not a real thing. What? And now it's about you being right? About not you, but the judge. And I'm right about fibromyalgia. They're not even thinking about the claimant. They just want to be right about fibromyalgia in their own world. And now they're trying to prove a point to me or to the claimant. This is not a real diagnosis.
Well, that's a sad fact. Yeah, it's a sad fact that there are judges that are like that. Just like there are surgeons who really are not the top of their game. It's across the board. And you can't, unless we have a robot or artificial intelligence decide, whether or not a person's disabled, you can't factor out bias. You can argue against it, but you can't factor it out.
Let's keep going because we have been at this for a while and we're probably going to break this up into a 4-parter. But number 5 we put down, and I think it's similar to fibromyalgia, is chronic fatigue syndrome. Why don't you talk to me about chronic fatigue syndrome and why it's hard to win? I mean, whether it's diagnosed correctly or, objectively or not, why makes it so difficult to win in front of a judge?
Well, it's because it's based more on the credibility of the claimant, because chronic fatigue means chronic fatigue, tired all the time, no energy. And with that, there's a whole panoply of additional symptoms that a person might have. Poor memory, very similar to fibromyalgia, actually, but a separate disease category. And if it hasn't been excluded as a cause of the claimant's problems, then the diagnosis of fibromyalgia probably shouldn't be made if it's actually chronic fatigue syndrome. And there are some objective tests that they can do. RA factor in the blood is one. If you have a high RA factor, that could indicate chronic fatigue syndrome. And the actual regulation does speak to some of these objective indicators of chronic fatigue syndrome that you're not going to find with fibromyalgia.
Yeah, so that's why it's a little bit easier in the fibromyalgia, but I would argue too that, and I'm not studying it and I'm not running numbers on it, but I just think that when judges see either a diagnosis of fibromyalgia or chronic fatigue syndrome, they raise an eyebrow of like, oh, here we go again.
Yeah.
Even if you point out all the studies and the factors and whatever else, there's a bias.
A bias
from a lot of judges, about not all, but that it's just not
it's not acceptable, like that, these types of diagnoses. And that's what makes it hard. I just think there's a bias against it.
Well, it's kind of like headaches. There's no objective evidence to support the claimant's claim. And so, I mean, I guess as a judge, what do you say? If you're going to say, well, you don't have chronic fatigue syndrome, even though a rheumatologist diagnosed it, I think you're just lazy. I mean, is that what the judge is thinking? And, when I was a judge, there weren't that many people that would come in front of me that were just lazy and, trying to get something for nothing. That's not people that are trying to get Social Security disability. For one thing, they've usually paid for it. They paid into the system for years, and now they want to collect it. But the other thing is, you're not going to get rich on Social Security disability. I mean, it's barely enough to survive for most people. And I personally don't know anybody who would want to be found disabled. That just doesn't sound real appealing to me.
Right. And you and I can do a whole podcast about kind of, are people faking it or not, and why there's no value, monetary value versus going to work. I'm sure a lot of people will come at me and like, oh, they don't have to work, they can just get money. But a lot of times you have to pay into the system to get any sort of substantial, I guess, and so yeah. But I want to get back to chronic fatigue and kind of our list of most difficult disability cases to win. The sixth one we talked about was your past relevant work, but and being over the age of 50. So, and how that's related, and maybe you can address that.
Okay, so over the age of 50, it's generally accepted that if you can't do your past work and you can only do sedentary work, the judge is going to have to find you disabled. Okay?
So let's define sedentary real quick. Sedentary is basically a sit-down job. You have to sit at least 6 out of 8 hours a day. And you're limited to lifting about 10 pounds or less, right? And that's considered a sedentary job. An example would be a lawyer and a judge. Okay.
Yeah. Yeah.
2 very sedentary jobs. Okay. Or a legal assistant or office worker or,
receptionist. Yeah.
Small process ruler, maybe sitting and standing, but yeah. Mm-hmm. So that would be a sedentary job. Sorry. Go ahead.
So if you're over 50 and you have a past job at the sedentary level, which was mostly a sit-down job, you didn't have to lift more than 10 pounds, you're not going to get the benefit of that presumption of disability, because it gets a little more complicated when we start talking about the burden of proof. But if a judge finds you can't do your past work, then the burden of proof is on Social Security to prove that you can do other work. And if you've done sedentary work before, I mean, it doesn't get any easier than that. So then a judge can just say, well, you can do sedentary work, and so I'm not going to find you disabled because you used to do sedentary work.
Right.
And then, of course, at 55, it goes to light work. If you did light work before it and you're over 55, if a judge finds you can do light work, then he would put you back to your past work.
Right.
And so, after 55, it doesn't really make a lot of difference. Go ahead.
Yeah. So light duty, I just want to define light duty for our audience real quick. Light duty is standing for 6 hours out of an 8-hour day and lifting 20 pounds, occasionally, and 10 pounds frequently. And occasionally means, I think 1/3 of the workday, if I remember correctly. And 10 pounds frequently means the rest of the time you're lifting up to 10 pounds. A popular example of that job would be like a cashier at the grocery store, grocery store clerk, someone like that.
Or a flagger. Yeah, there are, and a lot of I think fast food workers considered light work.
Yeah. Same.
Yeah.
Unless but maybe shorter crooks I thought are medium. I don't know. I have to. Let's move on. Number 7 was Lyme disease.
Oh yeah.